Good morning, everyone, and thank you for joining us for today's webinar event entitled Divorcing Later in Life, Top Planning Ideas and Mistakes to Avoid. This is a 1-hour session, and it's going to be hosted by Councilor Buchanan and Mitchell and the Jacobson Law Firm. And our presenters today are Jordan Egert, Cary Jacobson, and Seleznev. All of our presenters are very knowledgeable in the areas of divorce and financial planning and the legal component of divorce, each of which has their own core area of expertise. So if after the session you still would like to speak with or hear from our presenters, we would encourage you to reach out. We'll be sending you additional information tomorrow, a link to the recording. The session is being recorded, a copy of the slides, and then also the contact information for our presenter. So again, we would encourage you and invite you, if this is a topic that's relevant to you, to please reach out to their presenters. They're here to share their expertise and to help and assist you in the future if they're able. For those of you who submitted questions during the registration process, thank you so much for doing that. Your questions have been shared with the presenters and they have been built into the presentation today. However, if at any point in time during the next hour you have an additional question or if something comes up that hasn't been addressed, we would encourage you to use the chat box and to drop your question there. Our presenters will be concentrating on the content of the presentation and we'll be focusing on the Q&A towards the last couple of moments. So if they don't get to your question right away, don't worry, they will after the session. But please do use the chat box. So what I'd like to do now is just give a quick introduction of our speakers, and then I will turn it over to them. Our first presenter is Jordan Egert. He is a senior manager at CBM, whose primary area of accounting expertise is in divorce financial planning, litigation, forensic accounting, and tax advisory. He brings a keen eye and an empathetic approach to finding results for his clients, and in doing so, creates long-term peace of mind. He works with clients on various disputed matters to help them meet their financial goals and aspirations. His aptitude for practical problem solving helps clients develop and execute plans for strategic cash flow, asset tracking and projections, lifestyle budgeting, tax and retirement projections, asset and liability division, spending analysis, asset identification, and alimony and child support. He's presented for CBM and at various divorce industry groups, including at the 2022 International Academy of Collaborative Professionals Annual Forum and for Virginia Collaborative Professionals. Excuse me. Cary Jacobson is our second presenter. She is the founder and the managing partner of the Jacobson Law Firm, who has been practicing law for over a decade, having successfully represented clients in all facets of family law proceedings, including separation, divorce, custody, child support, post-divorce enforcement, and other family law-related matters. Through her experience, litigation, family law matters, Cary has found that conflict associated with litigation often can tear a family apart, making it toxic for children and their parents. However, as a certified mediator and as a collaborative divorce attorney, Cary has also seen how these forms of alternative dispute resolutions can lead to and foster successful co-parenting arrangements. She assists clients in choosing between mediation, collaborative divorce, or separation agreements in order to keep drama out of their divorce. Cary is involved throughout the legal community, including the Howard County Women's Bar Association, the Maryland Academy of Collaborative Professionals, Howard County Collaborative Professionals, and the Maryland State Bar Association. Our final presenter of the day is Seleznev, who is a partner and a director of wealth management and financial planning services at CBM, as well as a co-founder and chief investment officer of May Barnhart Investments, the firm's financial advisory subsidiary. Alex is a certified financial planner and a chartered financial analyst. He has 15 years of experience providing comprehensive financial planning and investment advisory services. Alex specifically focuses on pre- and post-retirement planning and helps individuals and families avoid market downturns to protect their life savings. Alex also presents regularly for CBM, including most recently at February 9th webinar on demystifying Medicare and April 20th market updates, which CBM hosts approximately every 3 months, and as a guest presenter on a May 24th session with Capital Senior Solutions dedicated to post-retirement planning ideas and considerations. Alex was finally recognized recently as a top financial advisor by Bethesda Magazine and is frequently quoted in financial media outlets such as Kiplinger. So we'd like to welcome you once again, and I'm going to turn this over now to our presenters.
Good afternoon, everyone. Again, my name is Cary Jacobson with Jacobson Family Law, and I wanted to start the presentation with explaining that there is no one way to have your divorce completed. In fact, there are multiple ways for your divorce, and that there are, process options that may be more suited to your particular situation. At the end of the day, the outcome of all of these process options is that there's going to be a determination of how your assets are going to be divided, potentially, if applicable, how much and for how long alimony may be paid. If you have minor children, it will also address things such as custody, the time sharing arrangement between you and your spouse, as well as child support. As you can see on this slide, starting with the direct process option, moving all the way down the spectrum to litigation, that your role in the process becomes less direct and also becomes more expensive. The costs associated with litigation far outweigh what it would be if you and your spouse are able to come to an agreement on your own. I would point out that even in the direct process option, that doesn't necessarily mean do it yourself. As you can see, both of those individuals in that scenario have attorneys that they are consulting with. However, the spouses are having direct contact with one another and really are the ones making decisions based on the information that they are receiving from their legal counsel. In mediation, generally, there's a mediator that is a neutral third party that is assisting the parties in reaching a resolution. And there may also be attorneys in the background that you are consulting with. In the collaborative divorce process, it's really a team approach, which is outlined there as a circle. Each party would have their own attorney, but everyone in that team is working together to help the spouses reach a resolution that works for them and their family. Under settlement advocacy, this is a less direct approach. In this scenario, as you can see, party one is only talking to their own attorney, and that person is relaying information to party two's attorney, and then relaying information back and forth to party two. I always equate this to the kids' game of telephone. And while it is a good approach for those individuals who cannot communicate effectively, you really do lose out on some of the underlying issues and concerns that both of the parties have, and those are being interpreted by the attorneys. So it is a good approach and it's definitely better than litigation, but it is not as preferable. And then obviously your last approach is the litigation. That is simply where you and your spouse are unable to reach an agreement yourselves, and so you are leaving it up to a judge to make the final decision. In my personal opinion, this is the last resort. And while there are some scenarios where that is required, we really do try to keep your cases outside of court because we believe that you and your spouse know your situation better than anyone else. To the next slide, Jordan. So now I'm going to talk about asset division. And I think it's important to get to the basics of asset division so that we know what we're dividing. So the first thing is, what is marital property? So marital property in Maryland is any asset that is acquired during the marriage, regardless of how it may be titled. So this means that if you have a car in your individual name, or your spouse has a car in their individual name, if it was purchased during the marriage or with marital assets, it is considered marital. If you have a retirement account that was basically acquired during the marriage, even though it's in one spouse's individual name, that is also considered to be a marital asset. Likewise, if there are jointly owned assets, such as a bank account, you have a house that is jointly owned, or your vehicles, those are going to be considered marital property. Next slide. There are some exclusions to marital property, and the first is inheritance. So if you receive inheritance, even if it's during the marriage, that is possibly going to be a non-marital asset, which would not be subject to division. Things that you may have acquired prior to marriage. So I just mentioned retirement accounts. So this is one that we often see is potentially partially marital and partially non-marital. So we see many situations where an individual may have some portion of their retirement account that they earned prior to marriage, and then earned additional retirement assets during the marriage. And so many times when we're dividing assets, we're looking at how much was premarital and how much is marital. Gifts that are received by a third party are also non-marital. What we typically see here, very common scenario is a down payment on a house. Now, sometimes this gets back down to facts. Was the gift given to the couple for a wedding gift, or was the gift of the down payment given to one of the individuals? So sometimes this is not as clear cut as simply I received a gift from my parents or the like. So, but that is a potential non-marital asset. Assets that you may have excluded by way of a valid agreement. So most commonly we see this as potentially a prenuptial agreement that says, how you're going to define marital assets or non-marital assets, or even a separation agreement. So we have situations where parties sign a separation agreement, they divide their assets, and then before their divorce is granted, someone then goes out and purchases a new piece of property or a new car. If it's already addressed in the separation agreement, then that would likely be excluded. And then the catch-all, which is assets that can be traced to any of these sources. So sometimes these assets can be traced, and that's an exercise in fact in your particular situation. Next slide. This is a common issue. How can non-marital assets become marital? So the one way is if they are commingled with marital property. So I've mentioned the inheritance before. So this is one that we see regularly. If you receive an inheritance during the marriage and you put that non-marital asset into an account in joint names, it's sufficiently commingled and is no longer a non-marital asset. Or even if you put it into an account in your individual name, but that individual account also has marital funds in it, that could sufficiently commingle it. Now, if you simply put your inheritance into a separate account and no other monies were deposited into that account, you may have been able to protect that. But, there are scenarios where it does become marital. Another situation that we see regularly is if the marital property was used to further acquire assets. So what we see here is one spouse may own a house prior to their marriage. And so whatever the equity is in that house at the time of marriage may be considered a premarital asset. However, the spouses then get married and they continue to make mortgage payments on that house. In that scenario, they are putting marital funds into the equity of a previously non-marital asset. And so it gets very complicated in figuring out how much equity is marital and how much of that equity is non-marital. Next, Jordan. Another issue that comes up quite often in our divorce cases is alimony, both from the question of, am I entitled to it? Do I have to pay it? And if so, how much is it going to be, and how long is it going to be? Jordan, next slide. So if your case is before a judge, the court has to consider a multitude of factors. And those include things such as the length of your marriage, how old each of you are, your mental and physical health of each person, the contributions each of you have made during the marriage. And that's going to be financial contributions as well as non-financial contributions. So it could be that one spouse stayed home and took care of the kids while the other spouse went out to work. The court would consider both of those contributions throughout the marriage. Whether or not the recipient, the person receiving alimony, can be self-supporting. So are they able to pay for all of their expenses on their own? How long it would take that recipient to obtain education and training to find suitable employment. So there may be scenarios where, one spouse has been out of the workforce for a period of time and their teacher license, for instance, has lapsed, or their nursing license. And so it may be that they need to go back to school or go back to a training to get new certifications in order to get employment. So those are the types of things that a court would be looking at. Another factor is the standard of living the parties established during the marriage. It doesn't mean that the court is necessarily going to equalize the standard of living for each party, but it is something that it can be considered. The circumstances that led to the estrangement of the parties. So this is really getting into the fault that, kind of the why behind the divorce. The ability of the party paying alimony, so the payor, to meet his or her needs while also meeting the needs of the recipient. So at the base level, it's saying, can the payor, do they have enough money left over in order to meet those needs of the recipient? Any agreements between the parties, again, going back to that prenuptial agreement scenario, there may be a clause within your prenuptial agreement that says that alimony will not be paid or received by either party. And the financial needs and resources of each party. So this could even be talking about non-marital assets. So I've seen scenarios where maybe the recipient doesn't have, cash flow because he or she isn't working, but they could be sitting on, an inheritance that's not going to be divided between the parties, but it is a resource that they have to make up some of the difference in what their monthly needs are. And so that is something else that the court must consider. Jordan, next slide. So some of the common questions we get related to alimony. The first is, alimony does not have a formula. There are no guidelines in Maryland that the court is required to abide by. Unlike child support, where there are child support guidelines, the court is not required to follow any alimony guidelines. That being said, there are some alimony guidelines out there that professionals will sometimes use to get a kind of a benchmark. One is called the Kaufman guidelines, and we use it to start the conversation. It's not the end all be all of what someone has to do, but it can be a good starting place. If this case goes to court, I will say that it's completely subjective. While the court has to look at all of those factors, it's truly in the judge's discretion as to how much weight they give each of those factors. And I will, my common scenario or talking point to my clients is, if you have 5 judges that hear the exact same fact pattern, they can do 5 drastically different things in how they decide the case, because it is subjective. So, taking a case to court because you want someone else to make the decision is not a slam dunk. I know Jordan may touch on this in just a moment, but alimony is no longer taxable to the recipient and is not tax deductible to the payor. So, that plays a part now in how many alimony awards are structured. And oftentimes, as I'm sure Jordan will comment, that sometimes there's an alimony buyout. So that's, how some people will agree to address their particular situation depending on what their needs are. Also important to note that alimony that is received can be considered income for mortgage qualification purposes. Now, there are specific rules on exactly what a lender wants to see, and working with a professional attorney, financial, and certified divorce lending professional is helpful to make sure that your agreement includes the correct language so that you can qualify for the next mortgage if you need to purchase a new property. All right, I'm going to turn it over to Jordan.
All right, thank you, Cary. So just to touch on a few additional items that Cary had brought up, I just want to reiterate that alimony, again, is non-taxable, non-deductible. This changed back with the Tax Cuts and Jobs Act reform back in 2017. Basically, any sort of separation agreement or divorce decree entered into after January 1st, 2019 is subject to these new provisions. So if you're being told or you read online from an article, it says, hey, you have tax deductible alimony, just be wary of when it was published or what information is being provided in there. A couple things that Cary had mentioned were, the ability to have flexibility in how alimony is structured. Again, going through the court system, it's very much up to the judges to ultimately make resolve or make a decision on what alimony is and for what periods. Outside of that period, however, or outside of going through the full litigation model, you do have quite a bit more flexibility in how you approach structuring alimony. Many of us think of alimony as simply being, X dollars for Y period. But as Cary said, we could have a buyout function of alimony in certain instances where instead of paying for 5 years, 10 years, 20 years, you might just have a lump sum payment that's discounted for taxes, or not taxes, I'm sorry, discounted for investment return, discounted for time value of money, etc. So we see all different sorts of structures available to spouses getting divorced. One thing I did want to point out, and Cary may be able to touch on this after we wrap up the presentation as well, is that as individuals become older and as divorcing spouses are aging further on, there could be a higher propensity, at least in the financial side of things, for a longer term of alimony to be paid out. So it's very possible in certain instances and circumstances that alimony could be a lifetime sort of time frame for divorcing spouses. And that's often when we see a lump sum sort of payment come out to trade off initial enrichment now versus a deferred stream of a payout. Again, the facts and circumstances are really what determines the right amounts. You could have deferred alimony to start 5 years later. You can start it now. You can take a break from it. Really, the sky's the limit as far as how we approach it. And that's why working with someone like Cary or Alex or myself is pretty paramount, just to make sure everything's equitable. So let's talk a little bit about tax considerations. Tax considerations, I applaud everyone for responding back to us. There were a lot of great questions, and we'll talk about as many as I can get through right now. So the tax considerations in divorce are an integral process in the marriage dissolution engagement. As we age, our net worth is generally continuing to increase. And as our retirement appears closer on the horizon, our tax implications are pretty compounded from there. So it's pretty crucial to have a really clear understanding of the potential liabilities, any available tax exemptions or credits associated with transfers of assets, and really how we would resolve an equitable dissolution of the marital estate in order that we are able to meet our financial goals long term. So we'll be able to talk about a few of the major, most pronounced tax implications for higher value assets in divorce, and just some general provisions to kind of get you on the same page of where we would be at in the financial tax world. So this is kind of the cornerstone, if you will, of tax implications as they relate to asset division. We have in the tax code, IRC 1041, which stands for Internal Revenue Code 1041, and this really defines pursuant to divorce. And what do these three words really mean? Well, Section 1041 is a provision that deals with the tax treatment of property transfers between spouses or former spouses incident to divorce. So it allows for tax-free transfers of property between spouses and ensures that the division of assets or the split of the marital estate doesn't trigger immediate tax consequences. So it really serves its purpose to help ease the financial burden on divorcing couples and tries to promote fairness in property settlements. So really the whole 50-page IRC code truncated down into one slide, as long as things are incident to divorce, again, tax-free. So we kind of get a freebie for 1 year after divorce, where effectively everything transferred post-divorce between spouses is considered incident to divorce and tax-free. And then the next step from there is anything that's transferred pursuant to divorce from year 1 to year 6, as long as it's notated or dictated inside the separation agreement, will allow those assets to be transferred tax-free. Beyond 6 years of the anniversary of the date of divorce, or the divorce decree being signed, generally assets transferred are presumed not incident to divorce. There are some special cases which are beyond the scope of our conversation, but happy to chat about that another time. So just a quick example. So let's say a couple is getting divorced, and as part of the settlement, one spouse transfers their interest in the marital home to the other spouse. Under Section 1041, completely tax-free, spouse A would just end up with no house, and spouse B would just end up with the full value of the house. Okay. So let's get into the crux of everything here. So the big issue at hand is that $1 in one hand isn't necessarily worth $1 in the other hand. I have an exhibit here that kind of gives a good example of what that might mean. So, for example, if we have $1 of cash in this hand and we have $1 of retirement in this hand, retirement assets can generally have some sort of deferred or long-term tax obligation due. So while we have $1 here, we may only have 40 cents or 50 cents in hand B. So in certain instances, we want to consider the impact that those taxes have on splitting up assets in our different columns. So spouse A may have more of the cash asset or more of the retirement asset, and spouse B may have less of one or the other. So the goal is really, in most states, to consider an equitable division of assets. So when we divide the assets, again, we just need to consider the impact of taxes. Without knowing the impact, we may end up giving up or trading something that may have more value than we expect it to. And on the flip side, we may end up receiving something with significantly less value. So for the items I want to touch upon that are generally high ticket dollar items, because again, as we age, these tend to appreciate and provide more equity, where the marital home, the rental properties, if we have any investment accounts or retirement accounts. So when we think about the marital home and splitting or dividing assets, really what we're trying to figure out is what is the value at a big picture level, and then how might taxes impact that as well. So again, we're trying to equalize columns here and make sure we have a fair distribution of assets. So when we're considering the value of a marital home, we might look at certain things like an appraisal, publicly available information such as Zillow or Redfin to kind of get just a bookmark or base level. And then we would say, all right, let's figure out what the taxability is on the value of the house. So The way we figure out what the gain is first is we would see what the current value of the house is, and then reduce it by any cost of the house, reduce it by any improvements, and any sort of potential selling costs in the future. So that will end up letting us know how much gain may be subject to tax. From there, we would figure out an estimate of tax and say, okay, instead of your $1 million house being worth $1 million, it's now worth $900,000, because if you were to sell it, you would have a $100,000 tax burden. One of the key takeaways that everyone should be familiar with is when you're valuing a house, there's a special section 121, which allows a primary homeowner to exclude up to $250,000 of taxable gain. And that could go up to $500,000 in case of a jointly owned or held home. So when we're thinking about equitable distribution of assets, while there could be a potential gain, that exclusion may wipe it all out and we may not have any tax at all. So there's special provisions when we're thinking about going through a divorce as far as when that when that section 121 exclusion may kick in. Happy to talk about that in Q&A, or if you have questions, feel free to email me after. But just know, all because only one spouse resides in the house doesn't mean that that full $500,000 exclusion is off the table. I did want to talk about rental property for a minute. In theory, it's very easy to look at value-wise. It's similar to the marital home. We would do some due diligence and figure out what the value is and kind of assign something to it. But the gain is much more complex. There's about 4 different tax components that get calculated and need to be considered when coming up with the net value of any rental property. And these calculations are often done by either your attorney or one of the financial professionals working inside of your engagement. The big thing to consider here is that with rental properties, they often provide passive loss carry forwards. And many of you are asking what those are. And passive loss carry forwards effectively are losses that are disallowed in your in your annual tax return based on income limitations. So that's a big mouthful just to say that these are potentially suspended and are another source of an asset available to one of the parties or one of the divorcing parties. So it's pretty important that we earmark those loss carry forwards, because they do have inherent value when we're thinking about splitting up marital estate. For investments, the big thing to take away here for tax purposes is that we want to make sure we understand the whole picture and major premise of what goes into value. Again, it's similar to really anything else, a rental property, a house, where the value is whatever the market dictates your holdings are. So we might have 1,000 shares of, let's say 10 shares of Berkshire Hathaway that could be worth $400,000. I don't know what the trading is right now. On paper, you may have $400,000 of value, but again, we need to track what the taxable gain is to figure out what the true net value of those investments are. So it's important that we understand what the purchase price was originally for those assets. And so if we're trading assets off, for example, and spouse A receives $400,000 of cash and spouse B receives $400,000 of investments, if, as and when the second spouse were to go and sell those investments, they would have a large taxable gain because there was such a large appreciation from the cost to the value. Something to consider too is that when we're thinking about splitting assets up, is the cost or the basis, the tax basis, generally follows the assets as far as where they're split up to. So if we're splitting up investment A and investment B, the basis or the cost of investment A would follow investment A and investment B to investment B. And why that's important is because if we just split an account, an investment account, a third or 2/3, a quarter, 75%, the basis, if not considered properly, doesn't follow in kind. So it's not a direct equal split of 25-75 or quarter, sorry, or half and half. It's really important to understand the cost. So the last major asset division item I want to talk about are retirement accounts. They come in 50 different shapes, sizes, flavors. The big takeaway here is that we really need to make sure we understand what is pre-tax versus post-tax. And when we talk about these, they're not all created equal. So an IRA account isn't equal to a 401, which isn't equal to a 457B account. Again, all sorts of different flavors, but when we're talking about them, again, it's important that we understand the premise of what benefit is offered or proctored by each account. So in a pre-tax world, excuse me, so in a traditional IRA or traditional 401k, some assets similar to that, down the line, the goal is that those are tax deferred. They grow tax-free. And then once they're pulled out of the taxable accounts, tax would be paid if, as, and when. Versus some sort of non-taxable retirement asset like a Roth IRA or a Roth 401k component. Those also grow tax-free, and then if, as, and when distributed, they are completely non-taxable. So, of course, this poses a question. What's the benefit of receiving one versus the other? Well, the benefit and the things that need to be considered are that if, as, and when they're distributed, there is a tax component that needs to be considered. So we might have an IRA account and a Roth IRA account, both at $10,000 each. But as we distribute it, it may be subject to tax for the traditional IRA account. So again, asset A may not be equal to asset B. And those are things we need to consider. There was a question about considering annuities and pensions. So we often see this in a DMV area, often as far as FERS goes or CSRS. Generally in the financial world, what we end up doing is looking at things one of two ways. We might value it based on a present value, which means what the annuity or pension is worth today on the future strings, or you might consider it just an if, as, and when, and divide it up as a cash flow sort of asset. So just some other food for thought for asset division and tax implications. We want to consider as well that tax refunds and liabilities can be dictated on how they're divided up. That would just be called for in a separation agreement. So just consider that, if you have a deferred refund, you don't want to be caught a year later or 2 years later when it comes time to be paid out from the IRS or from the state agencies with a question of, well, what do we do with this $20,000 check? Something I want to point out as well that's really important for divorcing spouses or people considering getting divorced is joint tax returns when filed means there's a joint tax liability. The IRS doesn't care if spouse A or spouse B triggered it. However, if you're married, that does not technically equal a joint liability in the IRS's eyes. So that might mean that spouses file a separate tax return and spouse A would be responsible for the taxes that are reported for his side of things or her side of things. So keep that in mind. It often gets mixed up a little bit. If there is an issue with a joint tax liability, there are ways to kind of circumvent it if a spouse isn't really aware of it. So it may be something that the IRS provides, like an innocent spouse relief provision where the spouse wasn't really aware of what was happening, or an equitable relief provision where the spouse makes a case to the IRS, say, hey, I didn't know, I had no clue what was going on. So these are all kind of ways to weave in and out if there is an issue with tax liabilities in the divorcing spouse couples. Okay, so we talked a lot about gross value, net value. The big question here is, how do we determine the appropriate tax rate when we're thinking about asset division? Well, in many cases, the answer is it depends. The approach that we may take in considering what a tax rate is when we're trying to figure out dividing assets for something like an investment account may be based on a current rate. That is to say, you have the ability to liquidate the account today. What would we consider the tax burden being as of today, this year? However, when we have assets that are more longer term, such as retirement assets, we might project a future rate. We might look at what your drawdowns are in retirement and say, okay, well, based in year 5, your tax rate could be 25 or 30%. That's the appropriate rate that we would use. So the takeaway is that when we're considering tax impacts, we really want to consider the appropriate rate based on the type of asset we're looking at. Talk about one or two other items here, and then we'll move on to another topic. But really, once we're divorcing, we want to also keep in mind that we could have really good opportunities for tax planning or arbitrage situations. Often what happens with divorcing spouses is we create a superficial year, if you will, with very low income or very low assets while everything's winding up. Once this happens, you can have all sorts of tax strategies put into play and start creating transfers of taxable assets into non-taxable assets. And again, we can talk about that later on as well. Keep in mind, tax rates can and will and do change. We have sunshine provisions set to come in 2025. So while we do know what taxes are today, and what they will be in the short term, it is possible that the information we know now may change in very short order. The last thing I'll leave everyone with is consider the timing of finalizing your divorce. There is a substantial amount of tax that can be saved or paid depending if you divorce on December 31st or January 1st. Just keep that in the back of your head, and it's often very meaningful to just even prepare a tax projection at the end of the year to see if you want to meet the December 31st deadline. Last thing I'll leave you with, I read this article about a year ago. I was in shock, but this is something everyone wants to consider. Really, the IRS says tax evasion is bad, tax avoidance is good. Not a problem to do tax planning. So at the end of the day, when we're coming up with our agreements, we can do a tax planning sort of look at everything, but we may want to specifically in our separation agreement say that there's an irreconcilable difference, and not that we're divorcing solely to save money on taxes. If we do, and the IRS says, hey, your divorce is null and void because of this, there becomes all sorts of tax repercussions that we don't want to get into. Okay, so with that, I'll turn it over to Alex on retirement and investment planning.
Thank you. Thank you, Jordan. Again, thank you everyone for joining us today. Again, I'm Alex Seleznev. I'm a financial planner. And as Joe mentioned earlier, my focus is really on pre and post retirement planning. And I will tell you again, in the context of our webinar today, I do work with a lot of clients who are former divorce clients, or actually some that are going through their divorce. So I step in and address certain questions. Next slide, please, Jordan. So in terms of your retirement plan, and again, just so you know where I'm coming from here, usually when I work with, married couples, and I'm not trying to necessarily overly generalize this, but very frequently one of the spouses really controls the family's finances. And when I use the word control, I mean it in a positive way, meaning that the other one is perhaps simply not all that interested in that. So again, that's very common. So if you're that spouse who in the past was not all that interested in the family's finances, divorce is certainly a very strong trigger event for you to perhaps not just revisit, but entirely reevaluate your overall retirement plan. And when you work with professionals like Jordan or Cary, they would certainly help you evaluate everything. And then someone like myself perhaps will really focus on it from the truly long-term perspective. So in terms of your retirement plan, how secure is it? Well, the answer to that question really depends, if you have a clear understanding of your income and expenses in retirement. Now, there are some popular rules of thumb that people tend to use, and I use them myself, like the 4% distribution rate rule. And essentially the way it works, you start with, let's say, a $1 million portfolio, and then you would begin to distribute the funds to yourself according to this formula. So 4% would make it $40,000 per year, adjusted for inflation. And then presumably you would not run out of money over the next 30 years. And by the way, there's quite a bit of basis behind this approach. It's a very well researched formula. Now, in practice, and specifically at this stage in the game, this approach and many other rules of thumb are not likely to be appropriate, because again, there are so many factors that will likely impact these decisions. As Jordan mentioned earlier, well, specifically your tax situation, the type of assets that you would receive as part of your divorce. I mean, that in fact can make a drastic difference in terms of, again, what you can actually distribute to yourself throughout your retirement. Now, one thing I will say when I work with the other types of spouses, if I put it that way, that focus on their own finances, which is great, and in many cases they do a pretty good job. The problem with that approach, though, is sometimes they make assumptions that make sense to them, when they, think about it. But in practice, though, not so much. And again, when we talk about different rates of return, sometimes they're too low or too high. Sometimes people assume that their taxes are going to be, higher than they are now, or much lower than they are today. And again, all of that can really lead to a pretty major issue in the long run. Now, so what's the solution here? The solution is to have a written plan in place. And I will be the first one to tell you that I'm entirely biased, because I am a financial planner and I develop those plans. But in practice, again, what happens, people have all of those ideas in their head and they sound, logical. Once you start looking at it from different angles, well, perhaps not so much. So you just have a lot of thoughts. It's not necessarily a plan. So how would you do it? Well, there are two ways of developing a plan. You can look at it from the top-down perspective, where you essentially start with everything you have, and then you solve for what you can realistically have in retirement. Or the opposite approach, when you say, to maintain lifestyle, I need X dollars. So how much do I need to start with to accomplish that goal? Now, what is of particular importance, and perhaps I'm inclined to say that's the most important part of the process, is to stress test your own assumptions and come up with worst case scenarios to really evaluate how well your financial plan would survive, essentially. I don't have to go far, almost a little more than 3 years ago at this point, in March of 2020, the markets were down by 31% in 17 calendar days. So for those who had no plan in place, well, quite a few of them panicked, made very irrational decisions. And as a result of that, they, harmed their future, their financial future, and their overall life, essentially. So again, it's very important that you have a plan in place. Next slide, please. So again, back to the context of our webinar today, my observation is many spouses, when they, or former spouses, I should say, when they go through a divorce process, they're still in that state of mind. They want to take more of a conservative approach. They want to feel comfortable, when they transition essentially into the next chapter of their life. And that's perfectly fine. But one thing I like to point out is that in the long run, there is a true cost, referred to it as the opportunity cost of investing too conservatively, or essentially having no plan in place. So this is what I discussed with one of my clients earlier this year. So she was investing mostly in, bonds, money market accounts, all of those conservative investments. So prepared a model for her showing that if she continues as is, well, at least based on the past performance results, she should expect a rate of return of 4.7%. If she decides to transition into more of a balanced allocation, and we don't necessarily have to go into much detail of what that means, well, the projected rate of return is a little more than 6%. Now, if you just compare the two numbers, perhaps the difference isn't all that significant, But in the long run, assuming you start with a sizable portfolio of $1 million, well, the difference is more than $700,000. And again, that can be used to improve your lifestyle. Perhaps you want to make some gifts to someone else, or perhaps you just want to save for your long-term care expenses. Next slide, please. So how do you protect your portfolio, or specifically, how do you structure it in a way that protects you in the long run? That is very important, because in the long run, it's really inflation and your longevity risks, risks that you should be focusing on, not so much the market volatility. Well, here's an example. We'll work with Jane, and it's not her real name, but we'll just call her Jane. She came to us again with a sizable portfolio, mostly in cash, in the money market accounts. So we sat down, we determined how much she needs to maintain her lifestyle. It's actually one of those easier situations, because the only source of income she had was her Social Security. So as a result of that, she really needed $6,000 per month to maintain her lifestyle. So we determined that. The next step is to essentially annualize it, determine how much she needs per year, multiplied by 7. Why 7? Well, that happens to be this average business cycle in the US, at least, which is essentially how long it takes for the markets to go from the top to the bottom and then back to the top, essentially. So we want Jane to be fully protected for at least 7 years. So mathematically speaking, she needs to maintain $504,000 in bonds, again, to protect herself. So, you simply divide that number by the total portfolio value, and that's how you come up with 36%. So the difference is there for growth, 64% in my example. What is important here, again, we're doing this based on Jane's specific situation. We're not necessarily considering her age all that much. I mean, it is a factor, but it's not necessarily the most important factor. But again, the goal is to make sure it's as personalized as possible to her specific circumstances. Next slide, please. So Social Security planning. Again, this is something that we would normally discuss as part of someone's financial plan. We can talk about this independently, but usually that's not necessarily the best approach. So some basics here for you to understand. And I'll actually start with the middle of the slide. So the so-called full retirement age, or FRA. For most people, it's anywhere between 66 and 67, and the maximum benefit this year in 2023 is almost $3,700. It just happens that this is perhaps the most optimal choice for many people, but not necessarily for most. And one of the reasons that's the case, or actually 2 reasons, is because you'll no longer be penalized if you decide to continue to work. And in terms of your life expectancy, you don't have to make any additional assumptions. Just average, essentially. You can collect the benefits as early as your age 62. In that case, why would you want to do that? Well, perhaps you have limited resources, you need immediate cash flow, and perhaps, which does happen every so often, you don't necessarily have that history of longevity in your family. Perhaps you're not doing all that well yourself. So that's again one of the reasons. And finally, age 70, which is the so-called late commencement age. The maximum benefit this year is actually close to $4,600 a month. That's the highest benefit you would receive. So there is no benefit of waiting any longer. One of the reasons, again, you would want to consider this is if you expect to receive more income from other sources, pension, earn income, or perhaps alimony payments. That is actually one of the main reasons why people defer to age 70. Next slide, please. So again, back to the context of our webinar today. So what rules would apply if you're divorced? Would you be eligible for benefits, meaning under your ex-spouse's account? Well, to qualify for the benefits, the marriage needs to last for at least 10 years. You need to remain single. You need to be at least 62 years old. And we always work with the assumption that your ex-spouse was actually entitled for Social Security benefits, which is the case, 99% of the time. Now, how much you would actually receive? Well, the answer to that question really depends. So, meaning depends on your ex-spouse's benefits. Now, if you're at your full retirement age, or FRA, you'll be eligible for payments that are 50% of your ex-spouse's benefits. So if he or she is due to collect $3,000, you'd actually receive $1,500 in this case. Now, what is important here under the new set of rules, and it's not all that new, it's been around for more than 5 years at this point, you have to be very careful with the so-called deemed filing rules, meaning that, in the past, what many people would do, they would collect under their ex-spouse, let's say at the age of 62, and then they would defer their own benefits to age 70 to maximize it that way. It's still possible for people of a certain age, but for many that is no longer the case because of the deemed filing rules, meaning that when you begin to collect the benefits, they would essentially look at the higher benefit of the two, and that's what you would be receiving. So you have to be careful. Next slide, please. So long-term care planning, and this is where I'm just going to go quickly here. This is a major concern for many, even under regular circumstances, and specifically for single females. And yes, I will put it that way. And the reason that's the case is because on average, females are expected to live longer, age 87, and for males it's actually 83. And in terms of their need for long-term care services, at least on average, again, if they need this type of care, they need it for longer, 3.7 years on average versus males at 2.2 years. Perhaps most of you are aware that long-term care is very expensive. The average cost for a semi-private room in our area is $300 per day. And here's, the average can be very deceiving because it really depends on community that you prefer. It can be quite wide. Next slide, please. So what are some of the ideas for you, again, to keep in mind? So usually, just like with your Social Security decisions, this is something that you would evaluate as part of your overall financial/retirement plan. Yes, this can be addressed independently, meaning should you have a policy or not, but that is usually not the best approach. Would it be possible for you to self-insure? Some people refer to it as self-pay versus, should you really buy some long-term care insurance? Again, that is one of the main reasons why you'd want to have those projections, why you want to have a retirement plan and really assess what it would look like if, let's say, at the age of 80, you need this type of care for 3, 5, and maybe 7 years. What kind of impact would it have on your overall financial plan? If you decide that you need to get some long-term care insurance, well, what kinds? There are traditional plans, essentially you pay as you go, and there are newer plans, and I usually refer to them as prepaid plans. Now, both are quite expensive, I will put it that way, and depending again on your personal preferences, perhaps you'll go with one over the other. And then the other 2 points I'll make in terms of the impact on your taxes, one of those misunderstood points, because people usually don't think about that, if, or perhaps for some people, when they need this type of care, so they actually transition into a CCRC, continuing care retirement community, will realize many of those expenses would be medical in nature, and as a result of that, they would be tax deductible, at least under today's rules. So if you run a projection again with someone going to a facility like that at some point in the future, chances are their overall tax liability will be significantly reduced, and as a result of that, have more cash flow. And then finally, which is what I touched on earlier, for those who are again single and expected to have above average longevity, this risk is very important. That's why, again, invest into conservatively in the beginning of your retirement, usually late 60s, early 70s, can really endanger, your lifestyle in the long run. That's what I have for you.
Cary, since we're coming up on 1 o'clock, I propose that we move over to the estate planning section, and I can come back to health insurance.
Sure. Okay, so I'm just going to run through this pretty quickly because I know we're coming up on time. But at the end of the day, everyone needs an estate plan. It's not just for those who are wealthy, but if you have any assets whatsoever, if you want to make sure that someone can make decisions for you, if you are unable to make them for yourself, it's important to have both a medical and financial power of attorney And if you happen to have any children, and especially minors, you want to make sure that you name a guardian or a trustee on their behalf. Another piece, that one of the reasons why this is in this slide, in this presentation, is a lot of people forget that once they're divorced, that they really do need to update their estate plan, because it's likely that you have named your spouse as your primary beneficiary. And so you want to make sure that you are passing along your assets to those you want to inherit from you. Go on to the next quick slide. And so if you had a prior estate plan and you have divorced, be sure to update your will or trust, your financial power of attorney, who's going to handle your financial affairs if you are incapacitated, your medical power of attorney, that person who's going to make medical decisions for you if you are unable to do so. And not only those things, but on your retirement account or your life insurance policy, your investment accounts, make sure that you update your beneficiaries so that they are, go in accordance with your estate plan. Because if you do not update your beneficiaries and it names your spouse, even if you've changed your will, your spouse will still receive your, the assets that you have outlined in that document. So I don't know if we have time for any questions, but that is, I think, concludes the end of our presentation for today.
And I'm also happy if anyone wants us to stay on for a few minutes, we can chat about health insurance for a minute or two, or if you have any questions and answers that you'd like us to respond to, please put them in the chat, as Cary had mentioned. So in the meantime, if anyone adding their questions, I just wanted to jump on, I'll just jump into health insurance for a minute or two. We had a question regarding COBRA coverage and what might happen, if you're covered by your for your spouse's employer. Well, we have a great rule called COBRA. It's something Omnibus Act. I forget the full designation of it. But really, if you're divorced and you're on your spouse's health insurance, you are legally the employer is legally obligated to extend coverage to you, which could continue for a period of up to 36 months. I just want to point out that having this option available is really an option. There's private healthcare, there's Medicare coverage considerations, etc. And although you may be able to continue coverage for 36 months, the coverage can be exceedingly expensive. So it's something that while available to you, you need to weigh out the benefit options, etc., to continue coverage on your spouse's plan. One other item I wanted to push everyone's attention is the federal employment health benefits. Keep in mind that if spouse is currently employed by the federal government, they do have certain benefits available to them. If they go and have FERS, CSRS, or a pension, something to that extent, the non-spouse could still be eligible for their life for federal health benefits. The way you might approach this is by having the out spouse receive $1 of annuity benefit at a minimum to maintain coverage under the federal guidelines. And it goes without saying, but the federal health plan is incredible. So if that's an option, it might be something worth considering.
All right, Jordan, I think we have a question, and I'm going to let you take it to start with. We have changed our mind on a specific investment asset that is in our divorce order filed 3 years ago. Is it better to go back for an amendment, or can I consider the gift option, including tax consideration?
So generally, and this kind of gets into the legal side of things and state specific, but generally, once your divorce decree is your divorce decree, unless you go back and modify and have an adjustment, the gift option would probably be your only kind of option in that framework. Not sure specific to DC or Maryland or Virginia or Delaware, whatever state it is, but that would be my approach. And I guess if you're talking about the gift option, Rebecca, you're discussing the lifetime exemption limit, which is also state specific. So the answer is it depends on the specific state, depends on the circumstance, and depends on the asset. Wish I could give you more information, but if you'd like to email me some of the details, be happy to discuss that with you further. Okay, so I think that's the only question we have, Cary.
Yeah.
So with that, our contact information is up on the end slide, up on your screen. We'll also be sending you a copy of our presentation as well for your reference and records. And please feel free to reach out to Alex, Cary, or myself if you have any divorce-related questions, financial planning questions, tax questions, or even just chat. We're always happy to help.
Thank you all.
Thank you, everyone.